Yes, okay, we'll postpone all the questions, we decided, and we'll start with Greece now. As I was saying before, Greece is a unique case in the European Union because it officially recognizes Islamic law, but only for, not for all Muslims, but only for Muslims living in Western Thrace. Muslim immigrants coming from other areas and even settling there, as far as I understand it, do not enjoy this separate channel. And adjudication by muftis is also recognized. What an interesting point to make, I think, it is that Islamic law is not codified by the state, it's not part of the legal system, but it is up to the mufti, case by case, correct me if I'm mistaken, to decide which sources to mention, which order of sources, how to interpret them. And as it happens with the Sharia councils in Britain or with Shia and Sunni courts in Lebanon, for example, while most of Muslim countries actually have codified their personal law status. And this has meant, in Greece as well in the other cases I mentioned before, that Islamic law, as it is practiced and, adjudicated, is far behind the recent developments in the Muslim world. For example, just make an example, I think we'll make much more examples about this. For example, the muftis, when deciding on khula cases, they usually require the consent of the husband as per classical law, as I've heard the Sharia councils do in Britain. So they refer to the traditional treaties on classical Islam, while in fact several countries are increasingly introducing, recognizing khula requests by women, even if there's not the consent of the husband. Pakistan has done that through its courts since 59, if I'm not mistaken. Egypt has done it in 2000 with a very controversial law. Algeria, if I'm not mistaken, has done it in 85 and 86, and it's increasingly applied within the courts of law, even when it's not in the legislature. And this ad hoc system is quite discretionary. It's very problematic when it comes to women's rights. And I think also this topic should come into the final general discussion. I mean, how is multiculturalism, how does it benefit or not the individual rights of women? Dr. Tsavousoglou will talk to us about the relation of Greek religious-based legal pluralism and its relation with the Greek constitutional order, and I think he will highlight some of its problematic aspects. He's a PhD researcher at Ghent University, and he has a double identity because he's also attorney at law, and he's written a couple of very interesting pages on a very under-researched and understudied subject, which is the actual working of Islamic law in Greece. And I'm sure that most people, in Italy at least, are totally unaware that Greece has this peculiar system. Okay, I leave the floor to him.
Thank you. Thank you very much. First of all, I would like to thank Professor Toniati for inviting me here in Trento and all the organizers for their efforts to organize this very special and very interesting event. So, the title of my presentation is Legal Pluralism in Western Thrace, Islamic Law and Constitutionality. The regulation of religious diversity has become increasingly demanding, particularly when Western polities are concerned. In the wider Europe, there has been significant expansion of Islamic culture that in turn has produced a relevantly proliferating demand of Muslims to adhere to their religious traditions. This reality has generated lively discussions regarding whether Islamic law is compatible with the European secular public order and whether it should be afforded recognition in such domains. In this context, Greece is the only European state that has officially adopted a system of religion-based legal pluralism. In Thrace, religious bodies of special jurisdiction presided over by muftis constitute the cornerstone of the application of Islamic law and the forum to which Thracian Muslims resort for the resolution of disputes and regulation of an array of their legal affairs. My contribution to the workshop engages with the relation of this religion-based legal pluralism with the national constitutional order. Specifically, I will address the aspects of compatibility of the former with the Constitution, the required yet problematic implementation of constitutionality control, and the judicial status of the religious authorities. The following analysis is based on the study of relevant scholarship with insights that were drawn from the examination of the case law of the local Sharia courts, local and regular courts. In addition, empirical knowledge is incorporated from my personal observations as an attorney in the region. For the purposes of the presentation, I will first introduce the current statute that is the basis for the application of Sharia in Greece and outline its defining features. I will then proceed to the description of the sui generis mufti jurisdiction and briefly refer to its main characteristics. Subsequently, I will focus on the relation of the law in force and the operation of religious jurisdiction with contemporary constitutionality issues and close with a few concluding remarks. So let's start with the statute that governs the application of Islamic law. Following the dissolution of the Ottoman Empire and the gradual expansion of the Greek territories, Islamic law in Greece was adopted as the personal law of the Muslims that were coming under the control of the Greek authorities. It is aptly contended and widely supported that Islamic law was introduced in implementation of a series of bilateral treaties contracted between Greece and Turkey. The last of these was the 1923 Treaty of Lausanne. The Treaty of Lausanne, under the principle of exemption from population exchange, resulted in the creation of minority communities in each signatory state. In a legal sense, it became the regulatory instrument of their protection and just treatment, while affording the people the right to adhere to their customs. To the extent that the Greek polity is concerned, the existing Islamic construction is received as a manifestation of freedom of religion for the Muslim or widely believed as Turkish minority of Western Thrace. This is a large community of people which in the vast majority reside in the homonymous region of northeastern Greece. Practically, the religious regime in the region can be defined as a reverse form of or a regime in succession to the former Ottoman millet system, where in the case under investigation, the minority status is attributed to the Muslim community of Western Thrace. Islamic law in the Greek system numbers approximately 100 years of application and coexisted with the Jewish personal law until the mid-20th century. It also survived the civil laws unification process that took place with the adoption of the modern Greek civil code and the code of civil procedure. In the Greek case, the constitution, although guaranteeing the freedom of religion, does not offer the immediate grounds for the accommodation of religion-based personal laws. It foresees, however, that international agreements, such as the Treaty of Lausanne, prevail over the typical laws when ratified and incorporated into the domestic legal order. Therefore, it is not the Constitution itself, but international obligations that constitute the grounds for the application of Islamic law. Today, legal pluralism in Thrace is governed by two domestic laws. Thus, in the Greek context, Sharia is recognized as national law. Islamic law as applied in Thrace bears a number of defining features. First of all, it is not codified. Thus, what one should expect to see administered in Thrace, in Western Thrace, is Islamic law without any reference to certain religious texts or sources. Secondly, the scope of its application is limited. Although not indisputable, contemporarily Islamic law as accommodated regulates only a specified number of the legal affairs of the Muslims of Western Thrace. So there is no wide application, nor it refers to all Muslims residing in Greece, only to the Muslims of Western Thrace. Most importantly, however, this religious regime is official. Its formal nature implies that this normative framework generates binding legal effects and that its regulations are enforceable. Regrettably, the statute in force is characterized by a major deficiency, that is, the lack of clarity. It is clearly notable that the lack of clarity results in differentiated interpretations of the law, which in turn entails confusion and legal uncertainty. Unfortunately, neither legal scholars nor the judiciary have yet reached unanimity regarding the scope of Sharia and the limits of the Mufti jurisdiction. And I will now proceed to the sui generis Mufti jurisdiction. The religious regime in Thrace rests on a controversial Mufti authority. The Muftis are granted by law multiple duties that include religious, judicial, and administrative responsibilities. Of this complex of activities, it is in a strictly legal sense, the most interesting yet problematic one is the administration of justice. In this context, the Muftis act as single-member religious tribunals. Their jurisdiction is a sui generis, special, great conception, considering that in the Islamic administration of justice, the Qadi is the genuine judicial authority, whereas the Mufti is a divine interpreter and theologist. Today in Thrace, we have three religious courts based in the three different districts of Thrace. According to the law, Mufti jurisdiction comprises resolution of disputes pertaining to Muslim marriages and divorces, personal relations of the spouses, maintenance, guardianship, custody, kinship, emancipation of minors, as well as Muslim wills and intestate succession. The decisions of the Muftis are final, and thus they are not appealable. This renders Islamic tribunals the only adjudicative authorities in Greece whose decisions cannot be substantially reviewed by superior courts. The only substantial control, according to the law, shall be implemented by means of constitutionality review. Therefore, it is stipulated that Mufti judgments cannot be implemented unless declared enforceable by the competent civil court. Moreover, Mufti jurisdiction has been repeatedly criticized for discriminatory treatment of Muslim women and the questionable way Sharia courts operate when handling cases of the faithful. Many studies argue that practices such as marriages of minors, child custody, Islamic divorce and succession induce dissimilar treatment between Muslim women and men. Similarly, primary research evidence and the study of the case law of religious courts reveal that Muftis may apply an irregular version of Islamic law that is mostly based on their personal appreciation and interpretations of Islamic law, but very irregular in essence. In terms of procedures, it is also argued that the process of justice administration falls short of meeting fair trial standards. From a lawyer's perspective, it is easily observable that litigation before Sharia courts does not follow certain rules while demonstrating high levels of informality. The procedures tend to be unstructured, resulting in the emergence of multiple hearings, or confusion and perpetuation of disputes. Most importantly, however, it is observed that Mufti judgments do not demonstrate fair levels of reasoning. Hence, one cannot truly understand or assess the regulation formulated by the religious authority. In effect, elements such as the lack of codification and means of appeal, informality, and the lack of reasoning actually show that this construction revolves around a broad margin of appreciation of the Muftis. So let's come to the core of my presentation. One may reasonably wonder whether it is possible for distinct Islamic norms to be tolerated within the frame of a liberal constitutional order, which, among others, foresees equality before the law, gender equality, and the right to judicial protection. This is a query that has never been easy to answer in the domestic scholarship. Part of legal scholars suggest that after Sharia was introduced by law, it has become one of the constituents of the legal order, that in turn they maintain eliminates any concerns regarding its compatibility. On the other hand, other scholars argue that the application of Islamic traditions, such as those mentioned before, marriage of minors, Islamic divorce, dissimilar mode of succession, are in direct conflict with the aforementioned constitutional rules. Moreover, they stress that Islamic justice, as dispensed in trace, cannot guarantee fair trial standards, concluding that Sharia, in any case, should be abolished. As a means of avoiding possible legal conflicts, theorists pose in favor of the optional character of the religious regime and the concurrent competence of the secular and religious jurisdictions. The first one means that all Muslim minority members should be able to freely decide to which legal regime they want to submit their legal affairs, the secular or the religious. In similar spirit, although Islamic jurisdiction is considered compulsory, the theory of concurrent jurisdictions suggests that religious and civil jurisdictions should be both competent in handling cases of the Muslims. Mostly this is conceived as a method of forum shopping or a second level of optionality. Therefore, it is argued that in circumstances where religious jurisdiction can induce breach of rights as conceived in civil law, the latter should be replaced by the civil jurisdiction. Paradoxically, none of the above alternatives have been widely accepted by the judiciary. The theory of concurrent jurisdictions was only very exceptionally adopted in the past. In fact, there is only one or two cases that I know. The issue of optionality of legal regimes, on the other hand, has generated broader debates. Contemporarily, this issue relates to the testamentary succession of minority Muslims. In Thrace, it is common for local Muslims to opt for the secular mode of succession instead of the Islamic, and often recourse to either disposition of property by in-life gifts or redaction of testaments before notaries. However, the validity of wills redacted by Muslims has been contested by a series of Supreme Court judgments. The court held that the inheritance relations of the Muslims of Greek citizenship are governed solely by the sacred Islamic law, whereby principally a testament does not constitute a legitimate ground of succession. Interestingly, the judgments tend to ignore that the Muslims of the region, as Greek citizens equal before the law, should bear the self-evident right of preference between legal regimes. Moreover, the Supreme Court overlooks that Islamic law is applied in Thrace as a concept of freedom of religion and minority right in general. The right to freedom of religion is well protected under Article 13 of the Greek Constitution. The court fails to see that, like many other rights, freedom of religion has both positive and negative manifestation. In this regard, individuals have or should have the inalienable freedom to believe or not believe, abide or not abide with the imperative of a religion. Therefore, any interpretation of the existing law that imposes subscription to a religion would be simply contrary not only to the domestic constitutional order, but perhaps also to the Article 9 of the European Convention on Human Rights. Furthermore, in recent years, it has been observed that there is a tendency to curtail muftis' regulatory powers and eliminate religious practices that sharply infringe upon the constitution and the public order. The regulation of child custody and parent-child communication, as well as the practice of proxy marriages, fairly illustrates the development. Despite that, according to the law, custody falls within the ambit of the religious jurisdiction, since around 2001, civil courts do not acknowledge child custody and communication as belonging to muftis' competence. Therefore, in the vast majority of such cases, they declare mufti decisions enforceable, yet dismissing contiguous provisions regarding custody and communication. In the same vein, in 2002, a circular was issued by the central administration prohibiting registrars to register marriages officiated by proxy, signaling the gradual abandonment of this practice. Notwithstanding the existing reservations, Islamic law is being applied as domestic law in Greece for decades. Given this, it is at least contradictory to see that when Islamic law is considered as alien law, it can be declared incompatible with the domestic public order and morals. This is generally the case when issues of recognition of foreign judgments, example given divorce judgments, arise before national courts, or Islamic law's implementation is expected in the frame of private international law. Respectively, the Greek Code of Civil Procedure postulates that foreign judgments can be adopted in Greece if, among others, do not contravene the public order or morals. And the respective civil code prescribes that foreign law rules cannot be implemented if they encroach on the same legal notions. It is perhaps the divergent spirit of the two legal systems that made Greek legislators to have reservations regarding the implementation of religious judgments. The reservations were plainly expressed by the introduction of clause of constitutionality. More concretely, as it is stipulated, mufti judgments do not acquire force of precedent, nor can they be implemented unless declared enforceable by the competent court of first instance. The regular court, it is not competent to review the decisions of Muslim authorities. It examines only whether each decision has been issued within the limits of the religious jurisdiction and whether its provisions are in compliance with the Constitution. Thereby, the law assigns regular courts the duty to control the adjudicative activity of religious courts in terms of constitutionality. The clause of constitutionality is a legislative device creating the requirement for mufti decisions to be in compliance with the Constitution. In view of the existing regime, this clause proves to be perhaps the only substantial instrument in terms of protecting fundamental rights. This is because the Constitution, while being the supreme source of law in the domestic legal system, enshrines and promotes gender equality and the right to judicial protection. Nevertheless, the reality shows that this measure has utterly failed to serve its objective. A recent national study commented that of a total of 2,679 mufti decisions, only one was dismissed by the civil courts on the grounds of contravention to the Constitution. Undoubtedly, the numbers are striking and reveal the failure to implement effective constitutional control. The law stipulates that muftis exercise judicial powers. That is, they are granted the authority to adjudicate on issues exhaustively enumerated in the law. This hardly conveys the meaning that religious authorities were accorded judicial status. Like in all modern democracies, the judiciary constitutes one of the pillars of the system of government, and most likely its status is outlined in each polity's constitution. Similarly, in Greece, the constitution delineates judiciary's fundamental features. Justice shall be administered by regular courts, and courts are consisted of regular judges. Regular judge becomes one who receives legal education. He or she is subject to the rules of the respective regulatory code for judges, while being appointed by presidential decree to serve as such for a lifetime. On the other hand, muftis bear none of the above traits. Muftis do receive education, but religious, not secular. It is also quite questionable whether indeed they are being trained to become judges. Along with adequate religious education, a mufti has to be of acclaimed morals and piety. Most importantly, however, he is considered by the respective law as a civil servant. Therefore, muftis do not enjoy a judicial status, but they are simply granted an irregular authority to adjudicate on disputes of Muslims. In line with this definition, the Greek Supreme Court describes muftis as a special judicial instrument of the Greek polity. In light of the above observations, it is evident that the Greek legal order has been indecisive in building a concrete position for Islamic law within its general body. Consequently, the latter has acquired a special but also controversial, ever confusing nature, rendering its relation with the constitution uncomfortable. Although Islamic law officially recognized and protected as a matter of religious freedom, at the same time there is a tendency to restrict its scope of implementation based on constitutionality argumentation. Certainly, the questionable way religious authorities exercise their powers plays a significant role in the generation of conflicts with the constitution, and shows that it is not necessarily the imperative of Islamic law that creates the problems. Today, the existing regime seems more like a residue of the Ottoman past rather than a working instance of respect of diversity and religious freedom. Certainly, the topic requires further investigation, both in the legal but also in the social sense. And this is an approach that my doctoral research adopts, while hoping soon to be able to shed light to the problematic areas of legal pluralism in Thrace. Thank you for listening.
Thank you very much. Ilker, I guess we'll proceed with the next presentation, which is about the way in which European Union courts contributed to the debate on religion and politics, and how they have played a very positive role on many levels, at least, and this is what Professor Ventura thinks himself, that they've played a very positive role, as can be gathered by the title of one of his very interesting papers, The Virtues of European Courts. I'm not sure about what exactly he's going to talk about today, because he's just told me that he's decided to totally revise his abstract. But anyway, he'll talk, I think, about European courts and their contribution to the debate. And yes, he's professor at the University of Siena. He's the author of many articles and books, most recently one on religion and law in Italy, which is another sort of unresearched, I think, topic, and also a history of religion in British, India, and South African courts. And he's been involved in the Religio West, a EU-funded project based at the University Institute of Florence. And later on, I will ask you what has been, if any, the relationship between Religio West and Religare, because that's not clear to me. Okay, I'll leave the floor to you.
Thank you, Professor Giunchi. Thank you so much for this kind of introduction. Let me thank, first of all, the organizers, the scientific committee, for having me here. I'm very grateful, and it's a privilege to share some thoughts from the perspective of a scholar in law and religion. So as I'm very grateful to the organizers, I must also say that they gave me a hard time with this title. Not being myself an expert in constitutional law as such, or comparative constitutional law, which explains why the first of the two basic assumptions for this paper is that I will look at constitutional law in Europe through the lens of the European Court of Human Rights. Very specific way of narrowing down the subject, but something which is more in tune with my research. Second basic assumption, as far as the methodology of this paper is concerned, is that I will look at religion-based personal laws through the lens of religious laws. Okay, I will not elaborate on this discussion about categories, although I'll be very much tempted to do so, again, from the perspective of a scholar in law and religion. But it is enough for the moment for you to know that the basic starting point for someone in law and religion is rather the category of religious laws, rather than more specifically the category of religion-based personal laws. And you will see this through the selection of the materials that I used for my presentation. Now, as far as the structure of the presentation is concerned, it's a twofold structure. I will sort of trace a chronological and conceptual history through 7 steps, and then I will finish by 4 points for conclusions. Now, these are the 7 steps, all of them through decisions by the Commission or Court of Human Rights in Strasbourg, starting from 1966, ending in 2013, 2014. I must say, extremely arbitrary on my side. I must say, this is really a very personal, subjective selection. This is the way I see the developments in this field from my various perspective. I take some risk with you today. We don't need to go through all of them. From the beginning, we can just move. Let me keep an eye on the time. Half an hour would be the allotted time, right? Okay. So this is the first step. This is the first step. And this is really a very sort of traditional church and state step, which can serve the purpose of illustrating some sort of passage of shift from traditional state and church matters and categories and concepts into an attempt to conceptualize religion-based personal laws. This is a very early case brought to Strasbourg. This is the European Commission. It's a decision on admissibility. The case was not admitted. So in terms of, you know, the big rulings by the Grand Chamber, this is extremely marginal, extremely preliminary, and very early in terms of chronology of the case law of the court. But the case itself is extremely interesting. It's a German Jehovah's Witness who is, of course, very unhappy of not being entitled to object to military service and be in jail, and not just, you know, the general pattern of this kind of conflict at the time, 1966, but he also submits that he's a minister of his church. And being a minister of his church, the submission is concerned with the special status of Lutheran and Catholic ministers in the country. So as a general citizen, he has no ground for claiming the objection and the exemption. But as a minister of the Jehovah's Witnesses, he can submit to the commission that he's been discriminated against vis-à-vis the special treatment which is reserved to Lutheran and Catholic ministers, who, they are exempted. Now, the rationale that is given from the German government for this discrimination is extremely interesting, because it's basically the rationale that I take as, again, an expert in my area, as very fundamental, seminal for the adjudication of religious laws-related claims in Europe. And their rationale is that the Lutherans and the Catholics, they accept the do-ut-des system. They accept the mutual benefit system between state and church. And therefore, they are entitled to a preferential treatment. Quote from this passage, the substance of these agreements between those churches and the state was an exchange of mutual benefits between state and church, do-ut-des in Latin. This could imply that while the state agreed to exempt ministers from compulsory service, the church agreed to give the state some influence on the appointment of holders of ecclesiastical offices, or to provide the armed forces with ministers in order to satisfy the religious needs of the soldiers. End quote. Very little emphasis here on religious precepts. Very little emphasis on religious laws. Much more on reasons why a government should and could treat differently members of different religious groups. And the key word here is exemption. A sort of system of exemption based, sort of invisibly based on religious laws, because religious precepts and religious laws here are at the same sort of elephant in the room, but very invisible. And at the same time, very heavy structure of church and state bilateral agreements. Let's move 10 years later, and this case is very important in the economy of my presentation because I can, through this actually passage from this decision, I can look at this word, pluralistic. So how does the court in 76 employs the term pluralistic? This is a case following the introduction in Danish schools of compulsory sex education. And some parents objected in the name of their parental rights granted by Protocol 1 to the European Convention of Human Rights, because that compulsory sex education would infringe upon their worldview as Christian believers. Now, they failed their case at the court, but the court made a very important point, which was later to play a fundamental role in rulings against Norway and against Turkey on compulsory teaching of doctrinal religion in 2007. And the point is the following, let me quote, "The state in fulfilling the functions assumed by it in regard to education and teaching must take care that information or knowledge included in the curriculum is conveyed in an objective, critical, and pluralistic manner. The state is forbidden to pursue an aim of indoctrination that might be considered as not respecting parents' religious and philosophical convictions." The kind of pluralistic, meaning of pluralistic in this context, reflecting the political and legal developments in Western Europe at the time, is completely different from what we understand today, of course, as legal pluralism. This is pluralism as no indoctrination. This is pluralism as, you see, coupled with the objective or with the critical, sort of open society, open to all views, different kind of concept. And state is not to impinge on parents' religion or belief based on pluralism. So it's sort of neutrality of the state. Neutrality of the state. Now, we jump to the mid-80s. Again, two cases which were actually declared not admissible by the Commission again. One related to Jewish law and one related to Islamic law. Mr. D, in this case, this is precisely the Cohen kind of a setting that Michel mentioned before, exactly the same, except that in this case, it's sort of, I cannot divorce my wife because I couldn't marry her later on as my ex-wife. So Mr. D has refused the get to his wife after civil divorce, and he's been fined for this reason by a French court. And he appealed because his view is that this sanction goes against the fact that he could not give the get because of his belief. And the point, and this application is dismissed, and the point which is made by the Commission is the following. The applicant does not allege that in handing over the letter of repudiation he will be obliged to act against his conscience, since it is an act by which divorce is regularly established under Jewish law. He alleges only that the Mosaic law provides that a Cohen may not marry a divorced woman, whether this is on ex-wife or anyone else's. In refusing to hand over the letter of repudiation establishing the religious divorce to his ex-wife, the applicant was not manifesting his religion in observance or practice within the meaning of Article 9 of the Convention. So you see a shift here. This is not a very solid kind of reasoning. I mean, we can easily see that, because there's a shift between this is not that heavy in terms of contradiction to a religious precept, although this is not completely clear. And by the way, we jump into, this does not fall within the scope of Article 9. This is not, so it's a sort already of what we were discussing today about the essential test, but of course framed in very different terms. So this is what I describe as denied Judaism-based exemption from the general law. Let's look at 3 years later, an example related to Islamic law. This is the case of an abduction for purpose of marriage of a girl, I think aged 14 or so. And again, this is a case where the application is declared inadmissible. And the applicant here is making a point about the fact that he's been convicted for abduction, but he was, as a Muslim, acting instead perfectly in line with his religious law. And again, I quote from the decision, the applicant complains that he has been prevented from manifesting his religion through his Islamic marriage by the operation of the legislation which makes it an offense to have sexual intercourse with a girl under the age of 16. By Islamic law, the applicant may marry a girl without her parents' consent if she has reached the age of 12. The term practice, as employed in Article 9, does not cover each act which may be motivated or influenced by a religion or belief. So this is less contentious in terms of the conduct being according to the religious law, and more straightforward in terms of not every practice related to a religious precept fall within the scope of freedom of religion or belief. 2001, 9 days before 9/11, a decision by the European Court of Human Rights Chamber, confirmed later, 2 years later, by the Grand Chamber, confirming the dissolution of an Islamist party after a extremely positive result in the Turkish elections, on ground of the party representing a threat to the constitutional principle in Turkey of secularism. Now, for the first time in this decision, the European Court elaborates a doctrine on the plurality of legal systems. So, in fact, this should be, based on the case law of the European Court, the only relevant case for the strict purpose of our conference here. That's why I have 3 slides on this one, because this text is very relevant, of a sort of first approach by the court, which is an approach of absolute denial of the plurality of legal systems. But as you will see, the dismissal of any conceptualization of the plurality of legal system as compatible, possible in the view of the Convention, comes with an extremely confused reasoning about why it should be so. So let's go through the text. The court considers that REFA's proposal that there should be a plurality of legal systems would introduce into all legal relationships a distinction between individuals grounded on religion, would categorize everyone according to his religious beliefs, and would allow him rights and freedoms not as an individual, but according to his allegiance to a religious movement. Such a societal model cannot be considered compatible with the conventional system for 2 reasons. Let's look at both of these 2 reasons. First reason, is to do away with the state's role as the guarantor of individual rights and freedoms and the impartial organizer of the practice of the various beliefs and religions in a democratic society, since it would oblige individuals to obey not rules laid down by the state in the exercise of its above-mentioned functions, but static rules of law imposed by the religion concerned. But the state has a positive obligation to ensure that everyone within its jurisdiction enjoys in full and without being able to waive them the rights and freedoms guaranteed by the Convention. So I stop here for a moment. It's a fantastic sort of encapsulation of the difference between state law, because state law is as a specific legitimacy in terms of principles. But then all of a sudden, what is wrong with the religious law is not that the religious law would be against those principles. There is no assumption in this sense, at least no explicit assertion of this in this text. It is rather a shift towards sort of the way I understand it. You might see it very differently. It's a sort of, because the law of the state is the law of the guarantor of basic freedoms, that law is meant to be more dynamic, whereas religious law is static, imposed by the religion. So this is a fascinating encapsulation of the difference between two, which then prepares the second argument, which is based on equality and non-discrimination. Secondly, such a system would undeniably infringe the principle of non-discrimination between individuals as regards their enjoyment of public freedoms, which is one of the fundamental principles of democracy. A difference in treatment between individuals in all fields of public and private law, according to their religion or beliefs, manifestly cannot be justified under the Convention, and more particularly Article 14, which prohibits discrimination. Such a difference in treatment cannot maintain a fair balance between, on the one hand, the claim of certain religious groups who wish to be governed by their own rules, and on the other, the interest of society as a whole, which must be based on peace and on tolerance between the various religions and beliefs, end quote. And again, there's something, I would say, very confused here in terms of different concepts coming and going. There is, again, some negative sort of comment or assumption about what religious laws should be about, this time associated with certain religious groups who wish to be governed by their own rules. But if we think back to 1966, and the Concordatarian Agreement with Lutherans and Catholics in Germany, what would the assumption of those churches in terms of their normative standpoint be about then? And then this point about discrimination, there's no description about how a distinctive treatment would be per se an unacceptable discrimination. And again, think back of the rationale of the Doe deaths in 1960 and 1966, which was instead based on legitimate distinctive treatment. 2006, one step further here, and this step further is related, in my view, to this notion of what is genuine, of how to assess the individual claim about religious precepts. The case of Kostevsky is a case of a Muslim in the Republic of Macedonia who is disciplined because of an absence, an unauthorized absence from work, on grounds of religious worship. So, unauthorized absence on a Friday in order to go to the mosque. And the reasoning of the domestic courts to dismiss the application, the petition against this sanction, is based on the fact that there's no evidence that he was indeed a Muslim. And even there were elements that would rather prove that this man would not live by what would be recognized as the common standard of conduct of a Muslim. So we are confronted here with an issue related to how to assess the real membership and entitlement of the relevant person. And I would take this, 2006, as sort of a reminder of, as suggesting somehow that elsewhere courts were confronted with the same problem. I'm thinking of free exercise claims in the US, for instance. Why would you be entitled to grow a bird in prison against, as a Muslim, against prison regulations in Arkansas, if so many Muslims do not take that as a precept, and at the same time, are you a Muslim because of that? Is there any proof of your genuine belief? And on the other hand, this is sort of late jurisprudence in the States Supreme Court about the genuinely held religious belief, up to the more recent Hobby Lobby. And on the other hand, India and genuine conversion, for instance, for the purpose of shifting from one personal law to another. So let's look quickly at how this point of the genuine character is made by the court here. Insofar as the applicant has complained that he was required to prove his faith, the court recalls that the court's decisions on the appeal against the disciplinary punishment made findings effectively that the applicant had not substantiated the genuineness of his claim to be a Muslim, and that his conduct, on the contrary, cast doubt on the claim in that there were no outward signs of his practicing the Muslim faith or joining collective Muslim worship. While the notion of the state sitting in judgment on the state of a citizen's inner and personal beliefs is abhorrent and may smack unhappily of past infamous persecutions, the court observes that this is a case where the applicant sought to enjoy a special right bestowed by Macedonian law, which provided that Muslims could take holiday on particular days, including the Bayram festival in issue in the present case. So some, dismissed application, but to some extent some opening by means of assessment of the genuinely held belief. Then from 2001 and 2010, we can find a string of cases judged by the court, whereas individuals have been protected from personal law. The first case is the Pellegrini case, a case where a decision by an ecclesiastical court, Catholic court, declared the marriage of Mrs. Pellegrini null and void, and according to Italian church and state law, this decision was later given effect by the Italian Court of Appeals through the concordatarian exequatur system. Mrs. Pellegrini applied against this, and the court declared admissible her application, and later ruled in 2001 that the decision by the Italian courts to give effect to the decision of the ecclesiastical courts adopted through a procedure where defense rights had not been sufficiently guaranteed to Mrs. Pellegrini, infringed her defense rights. But the court considers that Italian courts breached their duty of satisfying themselves before authorizing enforcement of the Roman Rota's judgment that the applicant had had a fair trial in the ecclesiastical proceedings. A second example, sort of closing this 2001 to 2010 period in this sense, a German case where an organist in a parish who had lost his job because of his irregular personal situation and had applied to the court again. Won his case. Germany was found in violation of Article 8, so the right to private and family life. But just what I found interesting here was to bring you to the very facts, to the very circumstances, in order to appreciate the family and personal implications of this case and the sort of private and family connotation of the case. The parish church dismissed the applicant on the ground that he had breached his duty of loyalty under Article 5 of the Catholic Church's basic regulations. In the light of the Catholic Church's fundamental principles enshrining the sanctity of marriage, the applicant, by having an extramarital relationship with another woman who was expecting his child, was accused not only of committing adultery, but also of bigamy. Final step of the 7, the other way around. Starting from 2012, 2013, 2014, in correspondence with the Hosanna-Tabor case in the US, which played a very strong a role in the, and especially in this Fernandez-Martinez case, there was a strong accent was put by the court on church autonomy, on religious autonomy, as a principle making for religious laws to prevail on laws of general applicability, which means at the same time, by implication, enabling religious communities, churches in these cases, to prevail on individuals who had been allegedly abused by the churches. This is the sort of the final case concerning a priest, a Spanish priest, Catholic priest, married with children, employed by the Spanish state under concordatarian regulations as a teacher of Catholic religion in a public school, who lost his job after taking part in a protest and having his opinions against church clerical celibacy and other aspects published in the press. Now, this is the way the court conceptualizes this preference to religious groups. Quote, the court notes that religious communities traditionally and universally exist in the form of organized structures. The autonomous existence of religious communities is indispensable for pluralism in a democratic society. The state should accept the right of such communities to react in accordance with their own rules and interests to any dissident movements emerging within them that might pose a threat to their cohesion, image, or unity. It is therefore not the task of the national authorities to act as the arbiter between religious communities and the various dissident factions that exist or that may emerge within them, end quote. Just a few lines before, in the decision, the court made a point about an opting out clause being the best guarantee for people like Fernandez-Martinez, which rejoins perfectly the point that Michel made in the discussion before. Pluralism here, sort of a bit of the pluralism in the Kelsen sense, but also, if related to such a strong religious autonomy doctrine, maybe also meaning something else, possibly depending on the strategies of actors. There's potential here for many different kinds of applications. And here I come to my 4 conclusions. What we have observed is what I would define a majority-friendly protection from personal laws. Someone might ask, what then in the Pellegrini case? Well, I would say, isn't that also a case of majority-friendly protection? Of course, it's an individual which is protecting against her church, but at the same time, on a ground which pushed the church itself, lately Pope Francis, to reform the functioning of ecclesiastical tribunals. So it's an individual which has been protected on a kind of agenda which can be seen as an agenda of the majority in terms of reforming the system of ecclesiastical jurisdiction and so on. So that's why I would also put the Pellegrini case into this idea of majority-friendly protection from personal laws. And of course, in the case of the abducted lady in the Islamic so-called case, or the wife of Mr. D in the French case, I would put them in the same category. Second conclusion, majority-friendly protection of personal laws. This would be the case with the last Fernandez-Martinez case and the other cases that the court has ruled in the same vein, like Zibenar and Ost in Germany, or the Sindicatul in versus Romania. And then third conclusion, religious autonomy to provide pro-religion justification for a majority-friendly approach to personal laws. Now, the point is, this has been used to some extent to reinforce religious personal laws for the sake of majorities so far. Mainstream churches in Germany, the Catholic Church in Spain, the Orthodox Church of Romania in Romania. But my 4th point, what about someday in the near future or less near future, applying this rationale to, in a different way, to different religious actors, so as to have religious autonomy to result in minority-friendly outcome. So I am just suggesting this possible outcome for the future. What I'm interested in, as you can understand, is to show that starting from a church and state Western European perspective, where personal laws of the Asian kind can seem really as something very, very, very far, we can probably come to some point where a conceptualization and a categorization like religious autonomy, which would again be framed in church and state terms, might result in something much closer to a religious personal law of an Asian kind. This is just my final question. Question mark. Thank you so much.
Thank you very much for your stimulating presentation. I won't take any time from the discussion, and I remember that Lorenzo Zucca and Arif Jamal had their raised their hands an hour ago, so I don't know if they still want to ask questions or intervene. And
my question was for Michael, but we have discussed about it. But though I think over coffee, but though I think I'll.
He didn't give me a chance to drink even coffee.
Yes.
yeah, but what about us? We didn't hear.
Yes. So I'll just repeat it because I think it is of general interest for everyone. So just to remind people about Michael's argument, he was making a parallel between Black American community and asking, well, what if you ask the community, what would they want? Asking the community is part and parcel of something that is desirable. However, I kind of raised the point that it's not easily comparable with the situation in Israel, because, what if we ask the Arabs the question, what do you want? And this very question is somehow problematic in many different issues. First of all, what if the community says that they want the millet system? Does this justify the millet system? But also, there is a difference between the Black American community and the Arab community, since the Arab community is morselled into many different religious sub-minorities. So some may want something, and other people may want something else. So how do you even start working this out? So at bottom, the question, just to repeat, is can we really ask the question to the community, and could we expect a meaningful answer from them?
And Arif?
Thank you. Well, if I can take the opportunity to ask one question to each of the first speakers. So Michael, my question was really just on the question of multiculturalism theory. If I understood the argument you were presenting, it was about a choice between sort of a common identity that one might have as a citizen, and then particular identities that one might have as a religious group, and getting locked into, say, a particular identity defined by a religious group. And I appreciate the qualifications that you made for conditions of genuine multiculturalism, and the models that you had presented was the US idea and what was happening in Israel today. And I'd like to just offer you another model and see whether or not this, what your reaction would be to that. And this is the Canadian model, which operates on a sort of hyphenated identity, where one can, on the one hand, have a particular identity, Italian-Canadian, Indo-Canadian, even German-Canadian, Ukrainian-Canadian, whatever it is, and on the other hand, share, because the second part of that hyphen is always Canadian, right? So there is a commonality without that commonality eliminating the particularity. So the Canadian, metaphor is a metaphor of not the melting pot like the US, but the mosaic. And Canada is also a country that sort of prides itself on its multiculturalism. So does that model of multiculturalism theory, did that solve the tension that you were raising? And then, if I could, to Prakash, a very quick question about what you're saying in terms of how caste is working, because caste does seem to be acknowledged in a lot of South Asian communities, right? So you'll see it in the South Asian press when people are advertising for weddings and things, they want particular caste. So I just want to understand how you think it is indeed operating within those communities, and then how one can sort of acknowledge it or deal with it in that context, because it's a live thing in those communities.
You can answer, I guess, okay. And then we'll pass on to other questions. Can we finish at 6:15 instead of 6? Okay.
Well, it's, maybe the Canadian example is a kind of an answer to Lorenzo, what you've said, because in Quebec you have a referendum. You want a secession, or you want to be part of federal Canada. This goes to the essential point I was kind of making. Do you want the imposition of Canada as a federal system, of having a province with all what that would entail? Or you want to break free and be totally independent. But once you vote in the referendum that you are for being part of federalism, then this would kind of justify the kind of restrictions that come with it. So this is the essential qualifying factor I was kind of aiming for. Now, as I told you over the coffee we didn't have, you know, it's like standards. We can speak of a reasonable person when we design negligence as a tort. We speak of a reasonable person. Now, to define what is exactly reasonable is not always easy to do, and you can always give problematic examples where we can differ. But we can easily say, if you drive drunk, if you're drunk and you drive a car, that's obviously an unreasonable action. And the case I'm trying to make is that you can have cases where it is bluntly against reason to presume that this is a multicultural, because it's not something that this community is desiring. So at least give me this as something that would prove the point I was trying to make. And the case I take in my article is the Greek Orthodox community as a Christian community that exists in Israel. So let's take autonomy and deconstruct autonomy. Autonomy, you govern by virtue of yourself. This is what autonomy means. Now, take the Greek Orthodox community. It's Greek priests coming from Greece and governing the local Palestinian Arab laity, the constituency. So it's foreign governance of the local community when the local community is asking for power over its community. Now, I think this is the guy who was driving drunk. This is bluntly unreasonable to call this a kind of a autonomy or multicultural governance of that community. So there is this qualification. You're right, it's not always easy to determine whether this community agrees or not. How would we determine that is not always something which is easy to determine. As I told you, in feminist theory, there's always a problem. Can women that are part of a very patriarchal community, when they are asked, are you for this jurisdictional authority of the ultra-Orthodox community, of the Sharia courts, or of the Christian courts? Why don't you ask the woman? And then the feminist would come saying, well, women that were brought up in a very patriarchal community would not be able to freely decide whether they are for or against, since they have been brought up in a patriarchal community. If they would be consenting, that consent would also not be that meaningful. So determining consent is not something that is easy to make, but at least I think we can think of cases where you can assume a kind of a consent or a disagreement with what exists, and at least that would count for or against that accommodation being regarded as multicultural or not. I accept the proposition that in terms of Canada, it offers a very interesting model, but as you would know, even then, you do have some problematic issues of I mean, you had this Sharia thing initiative. I think that was disregarded, and you're still having some issues. I've looked into some of the claims by immigrant communities in Canada who are looking for some accommodation but have been denied. And there's a question whether this is just or not. So it does resonate, but I do agree that the Canadian case is somewhat different from the American as well as from the Malay system, and it can offer a model. But still, if you take the Quebec experience, this exactly goes to the issues of, offer that group the chance, whether you want to secede or you want to be part of, and being part of would entail that you accept the restrictions. It offers some kind of a justification that you accept. I mean, I always tell my students, why is it okay for me as a professor to give you the grade and you should accept the grade that I would? This is also an internal restriction. You can think that you're a genius, but I don't think so, and you're entitled only to a B instead of an A. It's because if you don't like it, you can opt out. You can go to somewhere else and take another professor, take another course. I mean, how does the firm, the corporation, how is it justified that the corporation, as a shareholder, I should accept whatever this corporation is, how it is managed? It's because, you know, if I dislike what exists, I can sell my shares, I can opt out. But by accepting the shares, by being here, I accept some of the internal restrictions that exist. This is the essential, legitimate qualification I was trying to make, is that in some cases it is proper to at least ask the question, do you consent? And if it's clear to us that you cannot accept it, then it's a problem of saying that this is multicultural. And this goes also to the black community in the US. They were against segregation, and therefore this disqualifies segregation as something which is pluralistic or multicultural. So at least in these obvious cases, I think this is a very essential qualification for this design. This is the best I can do. Well, I guess so. We're going to miss another coffee.
Arif, I don't know what exactly you're asking for, because, I mean, I'll just sort of say something in a different way, which I think I've said already, which is that we don't have an adequate theory of what caste is today. We don't even know what a jati is, what the Indians would refer to as a jati. I think we don't know it. We have a sense, we have some intuitions that this basic mode of social organization is constituted around jatis, jati organizations, in Indian culture. And these have been transplanted to the diaspora. I know from my own experience in East Africa that this is the case, and in Britain it's the case as well. It may be a kind of a workable hypothesis that to say that maybe a jati is some kind of unit of ritual performance, right? Or a site of ritual performance that is, it's not founded on religion, it's not founded on anything, right? But it constitutes some kind of social organization which is a performative unit, a biocultural entity which is a performative unit, right? And it can be the center of forms of ritual activity. But the interesting thing about ritual is that they are not generally limited just to one kind of social organization or a social structure, right? So you can have rituals which take place in common between different jatis, right? Or with different jatis participating. And you see that among the Jains, right? So you will say that there are different Jain jatis, but for certain occasions they might come together to conduct certain types of performances, right? So I don't know if, as a hypothesis, we can explore that, but is that what it is? So in terms of the diasporic life of the Indian community in the UK, for instance, you will find a lot of formally constituted organizations, perhaps they have charity status and so on, right, around the idea of the jati, right? So the Oshwas, the various types of Patels, what have you, right? And they will have certain types of ritual performances in common, right, within the group. Now, actually, Werner reminded me that I should have said something about this. So a direct effect of the equality legislation, the Equality Act of 2010, and its containment now of the jati idea, the caste idea, is that somebody who is not part of that jati and, let's say, doesn't get tickets for Navratri event, right, like this sort of the festival of 9 days or 9 nights, yeah, which is conducted around the idea of the female energy, right, that constitutes the universe. he or she can say, well, you guys are discriminating on grounds of caste. Next thing you know, that organization has a legal action against it, is found in violation of the equality legislation, its charity status is compromised, thereby it's part of, certainly a big chunk of its funding is compromised, and they may, well, you know, because they will have action taken against them by the Charities Commission and so on, they might be forced to close down, yeah? So what you have, effectively, is some kind of very fundamental, potentially a very fundamental attack on the social organization of the Indian communities in diaspora, certainly in Britain. And I've heard that there are stirrings of this legislation they're gonna be enacted in Australia, perhaps Canada, US, and so on, right? And one part of the story I didn't say is that part of the ease with which there is a kind of revival of the old Protestant tropes is that actually the evangelical organizations are really firmly behind this. If you look at the Dalit bodies who are arguing for the legislation, it's not only Lord Harris who sits in Parliament, right, and tries to legislate for a community he doesn't belong to, but the Dalit organizations themselves are basically fronts for Christian evangelists who are connected. They have networks in European countries and in the United States and so on. So they are generating this kind of discourse. So if you put the two together, right, there is a kind of, let's say you can say, a Christian attack on the social organization of the Indian communities, the non-Christian Indian communities. That's the long and short of it.
Professor Harding and then Professor Ferrari. Oh, sorry, I don't know. Professor Harding was the first, for sure. I don't know about the two of you.
I don't know how much time you think we've got, but since Arif had two questions, and I always follow Arif, can I have two questions as well? Okay, anyway, stop me if you like, but my first one is to Ilker, a very interesting presentation about Islamic law in Thrace. Could you explain, you know, on the basis of your statistic of 1 out of 2,700 and whatever it was, you know, for 10 marks, can you explain why that constitutes failure? Because one might equally say that it constitutes extraordinary success. So I think it needs sort of unpacking a bit for 10 marks. So, and for another 10 marks, can you explain to what would you actually attribute that failure, assuming you can get 10 out of 10 for the first question, and then for Prakash, could you? I mean, I'm still not quite clear about your philosophical position here. I get the sociology of it in a sense, but I don't get the philosophy of it. So could you, for 10 marks, explain, you know, what is it that entitles the state to prohibit discrimination of any particular kind? And for a further 10 marks, can you explain how that would apply to the case of caste discrimination?
It's half a comment and half a question to Professor Tsavousoglou. Listening to you, I wonder whether we should not make a distinction between personal law regimes and minority rights regimes. In the sense that when I think of personal law regimes, I think of a state that accepts a plurality of legal regimes for all the citizens, India, for example. But in my opinion, Greece does not fit in this model. Greece, it looks to me like a state that applies a uniform and centralized legal system with the exception of a specific minority. So I wonder whether we can put Greece in the same basket with India, or whether we should say, no, Greece is a state with a minority rights regime, and minority rights regimes are not so unusual in Europe as personal law regimes are. So in this way, the exceptional case of Greece would become more understandable, in my opinion, in the European framework.
I have a question to Ilker also. You made a throwaway comment at some point early on in your presentation about the fact that this regime does not apply in the whole of Greece. So what you didn't say, what we need to know though is, if you want to evade that system, you simply move out of northern Thrace and go somewhere else in Greece. And then this whole system doesn't apply to you. So the question arises in terms of opting out. If people were so unhappy with this system, why don't they just leave? And maybe they do. I had a doctoral student who wanted to argue from an international law perspective for the right to language education of the Greek minority in Greece, the Turkish minority in Greece. And I said to him, that's too narrow. Can you please go and do some field work and ask your people what they actually think about this, rather than you coming from the outside and arguing about this. He was himself from that region, but he had clearly political agenda. So that go and ask, bring me fieldwork evidence. To his surprise, his own people told him that they didn't want to learn Turkish only. They all wanted to learn Greek and Turkish. And they sent their kids to Greek schools. They didn't even insist on Turkish schools. Yeah? So I'm wondering to what extent you are a sort of, or are reflecting or reporting to us an outsider perspective. You said fairly there is a mixed view on what is going on there, and there's no agreement. Yeah, but you're also a lawyer, and so it struck me also when you talked about this. You know, you are sort of inclined to argue against informal systems and against informal laws. Yeah. So I would be grateful for some comments, but I won't count marks.
Back to the speakers in answering these complex questions.
I will try fairly to answer all questions. Well, as regards constitutionality review, first of all, this survey does not belong to me. I didn't conduct a survey myself. So, although it is extensive, so we are talking about 2,000 decisions. Personally, I also tend to see from my own database that, yes, indeed, this is true. There is a failure of implementing the cause of constitutionality. But as regards the reasons for this, one very prominent academic I discussed with earlier this year, who is perhaps much more qualified than I am currently at this point of my career, he said that, first of all, Greek judges are not familiar with this regime at all. This is the first issue. And the second one, once they get familiar or once they visit the region and serve as judges in the region, they see, they adopt a stance that they feel internally that they do not want to get involved with internal matters of the community. So since there is huge legal uncertainty about how Islamic law is being applied, and in fact how should be also controlled, because we have this lack of clarity governing the whole spectrum of the legal regime, perhaps they find the very best solution for themselves to avoid getting involved by simply declaring enforceable all the decisions. It is wrong, first of all, because we miss the fact that legally we have a chance at least to correct the mistakes or the shortfalls of the religious regime. And there are extensive failure to protect human rights when we consider the Islamic law as applied in Thrace within this frame of Mufti jurisdiction. Yes, this is considered perhaps the only substantial instrument to protect human rights.
If I can add, it's very much the Israeli case as well. When you grant the group more jurisdiction over its constituency and that group happens to be religious, then you're undermining the rights of women and children because they become more vulnerable to the patriarchal norm of that religious group. So it's the more you're protecting the religious group, the less you're protecting vulnerable individuals within that group that happen. That's what I mean by victim. So, yeah, that's the case.
And for me, it is also clear from primary research evidence that it is not necessarily, as I already said, the imperative of Islamic law that creates the problem, but the way Islamic law is implemented and applied in Western Thrace. We have a structural problem and not a religious problem in essence, but still remains to see and verify the primary evidence we have from the field research. Let's come to your answer. The Greek case is a really peculiar case. To my understanding, we have a legal regime. I consider this as a legal regime in Western Thrace that besides there are already other opinions that they are saying Islamic law should be applied not only to the Muslims in Western Thrace, but to all Muslims residing in Greece. But my interpretation, and I believe from my extensive research that this is the mainstream interpretation of the law, that Islamic law refers only to the Muslims of Western Thrace. What I'm trying to say is that indeed we have a law that refers to persons, and this population is limited. So I consider this as a personal law of the Muslims of residing in Western Thrace, but residence is not an issue of essence. That's why it is personal law. If this Muslim, the Muslim of Western Thrace, moves, for example, from Thrace to Thessaloniki or to Athens, the law follows him. So you cannot opt out by residing out of Western Thrace. This is a huge discussion, in fact, because I steered, we also have this debates in Greece, I steered the discussions to the very primary question, and then who is considered Muslim? And in order to be able to decide the population that this regime governs. And there is still an ongoing debate, and nobody can essentially contribute and say who is the Muslim, who is considered Muslim in the region. I several times discussed with my professors in Thessaloniki, and they still cannot give a very good definition of who is considered Muslim in that case.
If a Turkish person moves from northern Greece to another part of Greece, the law follows him or her. That's not what I've been told. Is there disagreement about this? Is this unclear as well?
Yes, there is also.
Can you see? So is this like the argument, whether women have the right to divorce through Khula or not? That's also being debated, though it should be clear, but it's not clear. So everything is up for debate.
Yes, but the same law also follows those people when they travel abroad. For example, we have many Thracian Muslims residing currently in Germany. And as far as I know, although that I don't have concrete knowledge and detailed knowledge on cases, there were cases dealt in Germany where the judge had to decide whether, in the frame of international private law.
But that's different. That's private international law. So if a German judge would have to decide a case from northern Greece, yeah, then obviously that law would be relevant in the German court. But
Can I help out?
But not
just
if
for a
somebody
second?
moves to Athens. Or
It's known to be hybrid. If I would be a Greek individual living in that part of Greece, then Islamic law would not be governing me. So it's territorial and personal. It's neither just territorial, nor is it just personal. It can be both. So because a foreigner that would be living there would be governed by Islamic law? No. So you have to also qualify as belonging to that religion and living there. So it's both at the same time, right?
my issue was all you have to do is move away.
In that sense, it would emerge as being maybe territorial. If you move from that territory, then you would not be governed. But if you live in that territory, it's not enough to be living in that territory. You also have to qualify as. Yeah. Okay.
Are we to see the cases of conversion?
No, but you can. I mean, there's no joking. A lot of
Perhaps, yes, to clarify one more point. When, with an example, when a Muslim of Western race, for example, a couple decide to get married, at that very first step, they can choose between Islamic law and Islamic regime, Islamic marriage and civil marriage. That's yes. But when they make the decision and they get married in the Islamic way, in religious way, then afterwards they cannot opt out of the Islamic jurisdiction.
Even if they move to another part of Greece?
Exactly. But the theory that I described in my presentation, the theory of concurrent jurisdictions, refers to a second level of optionality, which says that even if you are married religiously, Islamically, then you should be able to choose between jurisdictions. Instead of Islamic jurisdiction and get a divorce before the mufti, you should be able to switch and mobilize your case and bring it before the civil court. And the issue of informality from my perspective as a lawyer, because I also represent clients before Sharia courts, not very often, but informality, the law, Islamic law as applied in trace, and when informality is considered, yes, it is a problem. And I will again answer with an example. There are no records of the court taken at the court. So there are no, often there are no written petitions. There are oral petitions. How can I possibly defend and help my client when there are no records kept, where there are no written petitions, and we should consider a Muslim woman who barely knows her rights, how can her defend herself in this informal structure? And by that means, informality, from my perspective, yes, it is a problem.
If you want to react to this, okay, very briefly, please. Yes.
If we have time.
I think we can stay a bit longer, right? Okay, yes, because it is very interesting.
Do we have right of exit?
No.
You agreed coming to this conference, so it's...
That was it, signed and sealed. Sorry.
No, I'm
From my experience, I see that generally Muslim women tend to litigate before mufti courts alone. Only exceptionally elderly people from the family, they can come with them. But we should also bear in mind that patriarchal interpretations of Islamic law exist, and they are also reinforced by family members who are male family members. So.
Can I add?
Yeah, sure.
In some of the patriarchal cultures, and this is a phenomenon I know, at least from the region I come from, sometimes you would find customary norms even harsher than the religious norms. And I will give you an example in terms of inheritance. Under Islam, the Sharia, a woman is entitled to half the share of the male heir to the estate. So if you have a family with a son and a daughter, the son would get 2/3 and the daughter would get 1/3. But as it turns out, a lot of the female heirs to the estate would give up their rights in total. That's the custom. And and sometimes it's very hard to distinguish between how culture would also be feeding the interaction in terms of the proceedings before these religious courts. So even you end up in a civil court, okay? And the female member would be giving up her half the share of the whole estate because of the tradition, even though this would be flying against the religious norms. I know it from polygamy, okay? Polygamy under Islamic Sharia, you can take up to 4 wives, but you would need to be equal among all the 4 wives. It doesn't work that way. You can't be equal. It's imaginary. But nonetheless, it's a tradition, and you find polygamy practiced in some regions and not practiced in other regions. Like among the Bedouins, it's more practiced in the southern part of Israel. But among other Muslim communities, even in Israel or in the Middle East, it's unheard of. It's not practiced, even though it is allowed. So when you look at some of these communities, this is another word of caution. Sometimes it's very hard to differentiate between tradition, custom, and the religious norms, and they come and play and feed each other in a way that it's incomprehensible from the outside. But this is in no way justifying anything. But this is sometimes the nature of things. I mean, you find the Islamic Sharia. Under Sharia, there is no appeal. Sharia does not recognize the principle of appeal. But in some places, you do have a Sharia appellate court, like you would have it in Israel. And this is a conflation from the other side. It is the civil system influencing the Sharia jurisdiction. I don't know what's the case in Greece, but can you be a non-Muslim and you can argue a case before a Sharia court? In Israel, you can, because you are qualified to appear before the Sharia court if you are a licensed lawyer. You can appear before, I can appear as a Christian before a rabbinical court because I happen to be a licensed lawyer. So it's a conflation that sometimes it plays from the other side. You find the civil system influencing the religious doctrine in another way, which you would assume that it would be shielded because of that autonomy. So it can play, tradition can move religious courts to be even more patriarchal than they happen to be, but situated in a place where you have a civil law, the religious courts can be more secular than they might usually be. So it's the context.
Thanks. I mean, I hear what you say, but I think your comments raise this big debate. Will any human society of whatever kind, because we're discussing personal law systems here, will any human society of any kind ever agree to a system of rules that systematically not just discriminates, but maybe even exterminates some of their members. Yeah?
It's not, extermination is a harsh, I think.
No, I'm thinking about the sati stuff, We talk a lot about Indians and sati burning their widows. I mean, what nonsense, yeah? It doesn't happen every day.
But
yeah?
you should
and
also
if it
not
happens, it
essentialize.
happens for different reasons.
But this is a question. It's very easy to essentialize religion and groups in the West. I mean, there's a very famous article by Susan Muller-Okin, Is Multiculturalism Bad for Women? And she picks and chooses different examples, and is this what you want to recognize under multiculturalism? And you find people coming and saying, when we speak about these traditional cultures, it is also wise not to essentialize. These cultures are not just about these conservative or these reaction to women. These cultures can also be different. So cultures like in the West, you have right extremists in Europe, but this is not Germany. This is one portion of that culture that might seem to be extremists to a foreign eye. And sometimes when you look at what exists in some of these cultures, I'm not saying it's always the case, but sometimes the case is that this culture happens to be diverse within, and you can find different genres of that culture. From the outside, it might seem to be one, but actually when you look inside, it happens to be of different kinds. And you do find a lot of Muslim feminists operating within my community against this jurisdiction, against honor killings. And it's not like what Muller-Okin would perceive this culture to be, just essential, one kind of a culture with one set of rules, but the cultures can be of different kinds. So it's a perception of how close you look at the culture.
Yeah, I think we're agreeing now on the need to take a sort of differentiated approach. Yeah? No?
Oh,
but I was warning about, us. Do we have a right as outsiders to these cultures to simply sit in judgment over them because they are other and they are religious or they are whatever, and they are therefore automatically bad? I mean, that's the risk I often perceive, and I've all my academic life I've been struggling with that, because that's often the argument that you hear. How can you argue in favor of not having a uniform civil code, for example, in India? Yeah, because so many feminists and activists think that that's the right method to get rid of all these discriminations existing in traditional societies. But in my view, that's not the ideal method. Yeah, by now we know that something has happened.
May I just quickly get, even the option to opt out before marriage is just based on a gross fiction, the fiction of equality. Because I am sure that, I bet that most men before marrying in Western Thrace would opt for the adjudication by muftis, and I bet that the woman's father would be in favor of it. So this is one of the many cases in Pakistan, for example. Usually, even when women are aware of the possibility of introducing contractual clauses to their favor, which is possible in South Asia, they are pressured, I know it for sure, by both fathers and husband-to-be, not to do it. It's considered dishonorable. So really, it is a fiction. We have to remember equality, but also in our societies, of course, not only in Sharia courts, etc. It's a fiction. We can aim at it, but it doesn't exist, and some laws are more clearly based on that fiction. Sorry.
Shall I earn my 10 points, or I'll try to? I don't know. Depends on Andrew. Oh, you don't want me to earn my 10 points, huh? Oh.
Sake of continuity, am I correct in saying that in Southeast Asia, sometimes it is different to distinguish between Islamic law and adat? Sometimes you think it is Islamic law and on the contrary it is adat, or vice versa. In other words, locally there is such a transformation of the legal system, that will be hard to decide which one it is, which raises also the question, which is very clever for me to raise at, 6:30? That, of course, even a uniform civil code doesn't assume that the law will be uniform, because, of course, the uniform civil code will have to be interpreted in a variety of circumstances with different sensitivities of the judge in different circumstances. And after all, this is what happens everywhere, regardless whether it is religious law, whether it is state law. So I wonder really to what extent to talk about religious-based personal law is not an overgeneralization that we just have to be aware has some hidden mistakes and tricks. So we should always try to connect the law to one particular place. And okay, that's all.
But you'll earn your points only if you're very brief.
Okay, I'll Karl Marx said something about Martin Luther having transformed the priests into laymen by transforming laymen into priests. Silvio will correct me, right, about that. Yeah, that's the point that Karl Marx is trying to make. So what we are seeing, I think, in legislation, contemporary legislation like the Equality Act, is a kind of secularization of that ideal of the monasticization of daily life. So if you translate it as a reaction against the caste order, a social structure which is constituted around caste, you can say that it's a kind of replay of the age-old conflict between religion and tradition. Religion in the sense of a Semitic religion. Short answer. Long answer in the break.
Professor Hardin?
I don't know if Roberto wants an answer.
Yeah, I think that also Professor Ventura's presentation is very much connected to the presentations tomorrow on European. Yeah, you want to
I just wanted to ask Marco about this. I mean, I'm sympathetic with the attempt to find in this kind of religious autonomy some kind of potential for application to the wider field of personal law, or as an entry point for personal law in the European legal systems. I don't see it. If you look at the experience of private international law cases in Western European countries, in the article which emerged from last year's workshop, which we had here, I basically said that Islam is by definition against the public order of Europe. If you look at the trend of cases in private international law, where Islamic law is applied as a foreign law, all due respect to the idea that it's actually a form of foreign state law, but it's Islamic law, let's say, right? It's routinely ruled out of court on grounds of public order, routinely, either by judges or by legislation. So I don't really see it, So yes, as a broad principle of religious autonomy and so on, but there's religion and there's religion, So again, that differentiation among different religions has to take place, and we don't like Islam. Let's face it,
Yes. Well, very quickly, there's two. It's two shifts in one. One shift is in the structure for representation of claims, which I see very much based on this minority-majority kind of development in Europe. Because if you take the British cases, Evada and stuff, that's very much former Christian majorities learning from minority groups to litigate for their rights in a different way, okay? So in terms of, really in terms of, at the same time, majority-minority shifts, this is much, in my opinion, this is well beyond the Christian versus non-Christian element, is those Christians who would see themselves in the position of a minority would now resort to concepts and categories that can help them make the claims in a different way, and they have a lot to learn. And from Muslims, for instance, you take the veil, the all litigation on the veil. This has taught many lessons to Christians in Europe, and there's a lot of similarities now. And on the other point is that this difference that you're making, I have the impression that this is no longer as big. This is no longer as big. I remember in India having a lot of conversation with Romila Thapa, and her point, as one of the most distinguished historians in modern India, was that it is extremely difficult to set a starting point for to look for any purity in the past. There's no purity for anybody. There's no purity, including for Christians. So Christians have been transformed by their colonial adventure. So even your categorization of Protestantism sounds to me a bit essentialist in the way it is construed. And you're looking at what Westerners brought in the construction of religion in the subcontinent, and you're probably neglecting how much their encounter reshaped Christianity back in Europe. And I think that this emerging, because this is just the surface of religious autonomy or personal laws, this can be easily misleading in terms of categories. But what is deeper, beyond categories, is that, in my view, everything is much closer than it looks like, and strategies can help us look beyond the surface.
I have the impression that the idea itself of authenticity is an historical product, and Professor Ferrari might correct me because I don't know much about it, but in the early years of the construction, the elaboration of a canon in Christianity as in Muslim law, they didn't really wonder much about it. They freely absorbed constitutional laws, man-made laws, etc., as long as, etc. It was clearly a man-made product to a great extent, and there wasn't much problem about it. So I have this feeling, but maybe this is one of the conversations that we can continue over dinner. And I mean, I would be happy to continue, but I think it's too late. So we'll continue over dinner, hopefully, and tomorrow. And I am told that we should meet in the hall of the hotel at 8 o'clock. 8:05, okay. And unless, of course, you want to briefly answer to okay. Our comments on authenticity.
Marco has raised like a whole question for a whole research program, so...
I mean, I would go on, but I don't think we can.
But obviously, I remain committed to my perspective, regardless of your point.
yes, we can.
Okay. To stop. Okay. Okay. Thank you very much.